A dung beetle, you know I like dung beetle jokes. A dung beetle walks into a bar. He looks at the bartender and says, "Excuse me, is this stool taken?" Well, I just got finished with a jury trial and I won 10-2 decision. I represented a real estate broker accused of breach of fiduciary duty. Of course, that would have licensing implications, absolutely decimated them. I came across this great video where these two auditors are looking to sue, from what I can tell, a lawyer who represented somebody I guess they have a beef with. Well, California, and this is California law now, I'm a California lawyer, not Illinois. It looks like this might be Illinois. Has a very, very nasty, in a good way, anti-SLAPP statute, which protects the First Amendment. And I have no doubt that Illinois has one too. So I just want to show you the mistakes that non-lawyers make that we find comical.
I come here to just serve a couple papers on you guys.
Serve papers.
One for your guys' client, and your Williams McCarthy for John Olavas.
This is hilarious. Look at her reaction. She's shocked. She doesn't know what the hell's going on. It sounds like they're saying they're serving them papers. Now, if you're the litigants, you can't serve on behalf of yourself. There are exceptions, but anyway, generally you just can't do that. And they're not serving them a pleading, such as a complaint. They're serving them a document that they created themselves, which has no legal effect really for them, but it has devastating legal effect against them, which is California's anti-SLAPP statute. Right now, by threatening litigation, they've now, in California again, they've now scored a jackpot with the California's Civil Code Section 47B litigation privilege, which is really strong. Its only exception is malice. Litigation privilege protects people from being sued for all kinds of stuff that's related to the litigation itself. It's supposed to prevent what's called derivative tort actions. So they can't just walk in like that generally and serve, and then the paper they're serving has no legal effect.
Okay, you want his assistant to serve you?
You could just, you could just serve it to him. Whatever's fine. If he's here, I'd hand it to him. Is he here?
No, he's not.
Okay, well then you can just give it to him. That'd be fine.
He's not here in the office. He's out for the week. So
that's fine. Whenever you get a chance, you can.
His assistant can take it.
Your name,
for
please,
what?
sir?
For what?
So I can call her and tell her that you're here.
I'd rather not give it right now.
Can you tell me your name?
It's Lawrence.
Lawrence?
Yes, ma'am. I have a delivery for him also.
Okay. Would you like to talk to his assistant?
Sure.
Okay.
What's it?
Lawrence, and you're with?
I'm sorry.
What, are you with an organization or?
No. Yes, I am.
With what? With who? Aubrey, can you come out front, please?
Now the assistant comes out.
Very
It's obviously puzzled too.
I'm on YouTube, Mr. Transparency Audits Illinois Press.
I'm trying to be rude. I just didn't want to get my name at the time.
So nice.
Well, usually if you're serving paper.
So they want to quote unquote serve somebody with a paper that has no legal effect in their favor anonymously while they're standing in front of them and potentially a party to the action. This is laughable.
It's through the sheriff's office, not.
Yeah, this is an intent to sue though.
Yeah, it's a little different.
It's not actually.
Yeah, it is a little different.
Okay.
Hello.
Now, let me tell you what's going through her mind. She works at a law firm. The last thing she wants to do is accept service of process on behalf of a client who may not even know that this lawsuit's going down. Secondly, the client may not give them authority to accept service, because once you accept service, you started the clock on their response time, which is usually 30 days from personal service.
I got a couple letters for Williams McCarthy and their client.
Okay.
Rockford, Mass Transit District. And he's got the same paper as well.
Okay. You want us to give this to Attorney John Holleyman? Okay. He's not in the office?
Whatever's fine. Get served.
Okay.
You guys have been served?
My name is Aubrey.
Okay. Nice to meet you.
I don't know if this counts as an official serving.
It's our letter.
Process. Okay.
It's not a court filing yet.
Right.
Okay. It's
Not a court filing yet, so you've established the litigation privilege here for us.
actually an intent to sue letter.
Let's now go to what a typical anti-SLAPP looks like. This is just a small part of it. I did one several months ago and threw out a $7 million lawsuit. There was like a 15-page brief. There was probably 50 pages in declarations and 400 pages of evidence, just to show that this case has no merit. There's two prongs, first prong, second prong. We have first prong when we're bringing the motion, has to be set within a certain period of time. You don't have a lot of time to oppose it. If it's not opposed, it gets granted, the case is over. And we're seeking legal fees from you now for filing a meritless lawsuit under the First Amendment. So First Amendment petitioning activity, if you're suing this lawyer, which is what it sounds like, or threatening to sue him for his role as an attorney representing his client in California, that is flat out anti-SLAPP territory. So as you can see, I didn't want to redact it, so just to knock it out, here's the section for the anti-SLAPP that I said was applicable. E4 is the catch-all. And what they basically say is, hey, you can't sue a lawyer for being a lawyer. And if you do, you walk right into the anti-SLAPP statute. And so there you have it. Dangerous to walk into a law office and tell them that you are intending to sue them because you just helped them invoke, at least in California, the litigation privilege. It's dangerous suing lawyers. And in this instance, suing a lawyer for being a lawyer, nah, you lose. I hope you enjoyed the video. I think there's no doubt that Adam and Eve ignored Apple's terms and conditions. Let's try another. The lawyer is from New York, thinks he's a big shot. He's driving down the side roads of West Virginia. Sheriff gets behind, pulls him over. Sheriff gets out, license, registration, please. Lawyer says, hey, I didn't do anything wrong. He goes, yeah, you didn't stop at the stop sign. He goes, I was slowing down. There was no need to stop because there was nobody there. And the cop says, listen, man, license and registration. The lawyer says, okay, I tell you what, I'll make you a deal. If you can show me the difference between stopping and slowing down, I'll give you my license, registration, and you can write the citation. The sheriff goes, okay, fair enough, but exit your vehicle. The lawyer gets out. And the sheriff gets out his nightstick, starts beating the crap out of the lawyer. And the lawyer says, stop, stop. He goes, well, do you want me to stop or do you want me to slow down? Hope you enjoyed it.